3, 2, 1.
Hello, and welcome to this panel. It's a pleasure to be with you. I think I can speak for all the panelists in saying that this should be a wonderful panel. I wish we all could be together to talk about some of these issues because I think that the University of Michigan and the Federalist Society put together a wonderful group of speakers all around and a great panel at every level to talk about the various issues facing us. This panel, which I think is the last of the 4 or 5 major panels, we're going to talk about horizontal federalism and interstate relations. In particular, some of the topics we hope to cover include personal jurisdiction, choice of law, full faith and credit, extraterritorial regulation, state borders, sovereign immunity, and other issues that have led to dispute between and among states. I think the format's going to be similar to what we would have done had we been live. I'm going to introduce each of the panelists, and then each panelist is going to give an 8 to 10 minute talk. And then we are going to entertain questions both for me, Judge Strauss. I should have introduced myself as the moderator. And then also we hope you will pass along questions through the Google Meet program so that I can we can pose them to the panelists. We had a conference call beforehand, and we decided on the order in which the panelists will talk. And we're going to start with Professor Doug Laycock, who is the Robert E. Scott Distinguished Professor of Law at the University of Virginia. Professor Laycock is one of the leading authorities on the law of religious liberty and the law of remedies. He has taught and written about these topics for more than 4 decades. At the University of Chicago, the University of Texas, the University of Michigan, and now at the University of Virginia Law School. He has testified before Congress. He's argued a number of cases, including 6 cases before the United States Supreme Court. And he is also a fellow in a very distinguished group, the American Academy of Arts and Sciences. And so I will turn it over to Professor Laycock to give the initial presentation.
Are we on? Can you hear me? So interstate relations is an undeveloped and certainly undertaught area of constitutional law, but the constitutional text devotes considerable attention to converting states from an international relations model of separate sovereigns to an interconnected and cooperative parts of a single nation model. There's the Privileges and Immunities Clause in Article 4, the Full Faith and Credit Clause, the Extradition Clause, the Free Navigation Clause, the Supreme Court's jurisdiction over suits between states, the prohibition of war or diplomacy between states, prohibition of state taxes on imports or exports, and of course, one constitutional abomination, the Fugitive Slave Clause. I want to speak today about 3 large principles that are embodied in 2 of those clauses and a constitutional structure with clear constitutional assumptions that have strong implications for choice of law. So for students who haven't taken conflicts, choice of law is the law that decides which state's law to apply in interstate disputes. If people from 2 different states have a collision or make a contract or interact however and a lawsuit results, which state's law applies? This is a question about the allocation of authority to govern. And allocations of authority are what constitutions do. So the Constitution ought to speak to this question, and it does, but what it says has been almost wholly ignored. Even if you haven't taken conflicts, you probably saw Erie Railroad versus Tompkins in the first year. That's about the choice of law between state and federal law. And the Supreme Court said it's a real problem if the result in a lawsuit depends on whether it's filed in state court or federal court. It's a real problem if no one can know the law that governs them until the litigation begins. We have all those same problems with respect to choosing between the law of sister states, but the Supreme Court has almost entirely abdicated any responsibility for that. So I suggest 3 principles: equal citizens, equal states, and territorial states. First, all citizens of the United States are equal, and each state must treat citizens of sister states as equal to their own. This is embodied most explicitly in the Privileges and Immunities Clause of Article 4. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So when I travel from my home in Virginia to Michigan, Michigan has to treat me for most purposes as though I were a citizen of Michigan. I am entitled to the equal protection of Michigan's laws and to equal concern and respect in Michigan's courts. And that means that Michigan cannot apply a popular academic approach to choice of law called interest analysis. In its original form, and to a significant extent still, interest analysis says that if I get in a dispute or a lawsuit with a resident of Michigan, Michigan court should apply the law that most benefits the resident of Michigan. Michigan courts can't do that. They have to treat me and the local resident equally and choose the applicable law without regard to whose ox is gored. Now, the Supreme Court has applied the Privileges and Immunities Clause vigorously to some things and not at all to other things, and not at all to choice of law. And that, I think, is a mistake. There is no choice of law exception to the Privileges and Immunities Clause, and we know it was aimed at choice of law because of the diversity jurisdiction. Hamilton and the Federalist said that diversity jurisdiction exists to enforce the Privileges and Immunities Clause. Out-of-state citizens are entitled to equal treatment in the courts, and to ensure that they get it, they can go to federal court instead. And Congress created or granted the diversity jurisdiction in 1789, didn't get around to federal question jurisdiction until 1875, so we can see which one was more important at the founding. Second principle, equal states. States must treat sister states as equal in authority to themselves, and sister state law as of equal authority with their own. Every reference to states in the Constitution treats all the states generically. There is no suggestion of any inequality between them. And simultaneously, the Continental Congress and the Northwest Ordinance and the First Congress and the less famous act to govern territories south of the Ohio provided that new states shall be admitted, quote, on an equal footing with the original states in all respects whatever. And that language has been part of state admissions acts ever since. The Supreme Court has long treated the equal footing doctrine as of constitutional status. And with respect to choice of law, we have the more specific terms of the full faith and credit clause. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Congress is given authority to further implement this guarantee, but the first sentence is self-executing, and Congress has legislated more or less in the terms of the Constitution itself. Now, it is long settled that if a sister state had jurisdiction, this clause makes its judgments binding everywhere. The judgment is entitled to full faith and credit, and the Supreme Court has a body of rules for when state courts have jurisdiction and when they don't. It is also agreed that acts includes legislative acts. But with respect to acts and with respect to common law rules, which are also embodied in judicial proceedings, the Supreme Court has let states do whatever they want. They are free to ignore sister state acts, to give them zero faith and credit, but the Constitution requires full faith and credit. Full is the most credit that can be given. It is the same credit the adjudicating state gives its own legislation, which is what Congress said in the Implementing Act, which dates from 1789. Section 1738 of Title 28, and it says, such acts, records, and judicial proceedings, when properly authenticated, shall have the same full faith and credit in every court within the United States as they have in the state from which they come. So the local law and the sister state law are entitled to the same full faith and credit, but only one of them can be applied. How do we know which one? The full faith and credit clause cannot work without choice of law rules. We need rules for deciding which law to apply, but the Full Faith and Credit Act doesn't specify those rules. It does eliminate some possible rules. Choice of law rules cannot be premised on a preference for one state's law over another. A state cannot just choose to apply its own law all the time, or the law it thinks is better, or the more modern law, or the pro-plaintiff law. Those are all academic proposals about choice of law rules. It cannot refuse to apply a sister state's law because it is contrary to the forum's public policy. We can do that to Libyan law, but not to a sister state. Choice of law rules must be content neutral. Where do these choice of law rules come from? Founders didn't put them in the Constitution, but they had choice of law rules, and they assumed that those rules would continue. And the founders created a fundamental division of authority between states. States are divided by territory. This is not explicit in the Constitution, although some clauses clearly assume it. It is explicit in state constitutions and state admissions acts. States are very carefully defined, and they are defined in territorial terms. choice of law rules have to be based on this territorial division of authority. That does not mean they have to be wooden or oblivious to state interest, but they have to start from the territorial division of state authority. We have to identify the specific point on which two states disagree and ask where the facts about that point occurred and which state has the greater interest in regulating those key facts. Key facts may be a relationship between two people rather than an event. Many classic choice of law problems arose from the importance of relationships. So if a married couple gets in an out-of-state car wreck, the local rules of the road should apply, but spousal tort immunity and any other rules about the marital relationship should be governed by the law of the marital domicile. State interest here must be defined without regard to which litigant benefits. Once we identify the territorial rule based on a neutral assessment of interest, we should apply that rule no matter who wins or who loses. And that would end situations in which the home state litigant always wins, in which forum selection is outcome determinative. It would end the problems Erie set out to solve for state and federal conflicts. So equal citizens of equal and territorial states. That's the title. It's been a while, but you can look it up in the Columbia Law Review.
Thank you, Professor Laycock. So now that I've kind of figured out this technology, I do want to make a couple of, and figured out how to mute and unmute myself, hopefully. I want to make a couple of quick announcements. One is that we do not have Professor Mortensen today. He got called away on on sort of a last-minute family obligation, and so he can't be with us. But we're going to continue on without him, and I know all of our panelists are more than capable of filling the void. And secondly, I should more formally introduce myself. Judge Strauss, I'm a judge on the United States Court of Appeals for the 8th Circuit, and I used to sit on the Minnesota Supreme Court. So a lot of these issues that we're discussing today are issues of interest, like choice of law, were things that I dealt with when I was a justice on the Minnesota Supreme Court. So I think that we're going to have an excellent discussion today. Our second speaker is Professor Will Bode, who you may know from his occasional blogging on the Vala conspiracy. He is a professor of law at the University of Chicago Law School, where he teaches federal courts and constitutional law. He's also the co-editor of a casebook on the Constitution of the United States. Prior to becoming a professor, he clerked for then Judge Michael McConnell on the 10th Circuit and later for Chief Justice John Roberts. He's also been a fellow at the Stanford Constitutional Center and was once a lawyer at Robbins Russell in Washington, D.C. I will turn it over to Professor Bode.
Great, and I think I just figured out how to unmute myself as well. Thank you all for having me. As Judge Strauss as Professor Laycock just noted, one of the main topics in interstate relations is the question of what's called choice of law, which sounds very technical, but fundamentally is the question of who governs, of which state gets to govern any given transaction. The same kind of question comes up at the federal level, federal law versus state law, but it's dealt with by the supremacy clause of the Constitution, which makes clear that if a federal law is constitutional, it's the one that governs. But there's no supremacy clause for state law, which is part of what has forced people who worry about this question to look harder and elsewhere for some sort of hint about what state is supposed to govern what transaction. Now, as Professor Laycock also noted, this is an area where the Supreme Court has largely abdicated any control of the topic of choice of law. And just to give a concrete example, in 1981, the Supreme Court decided a case called Allstate Insurance versus Hague, which a learned scholar has called one of the most indefensible Supreme Court opinions on any topic ever. And with due apologies to Judge Strauss, it's a case that comes from the Minnesota Supreme Court, where a man named Ralph Hague was driving a motorcycle in Wisconsin and got into a car accident. Now, once upon a time, it was well settled that car accidents in Wisconsin were always going to be governed by Wisconsin law. That rule started to change over the 20th century, depending on whether people were from other states and so on. But this should have been an easy case. Mr. Hague was in Wisconsin. He was from Wisconsin. The other driver was from Wisconsin. He lived in Wisconsin. Pretty much everything about the trip and the accident involved Wisconsin. But The lawsuit was brought in Minnesota, which had a law that was much more favorable to Mr. Hague. And the Minnesota Supreme Court seized on, well, really basically one fact, which is that Mr. Hague did work in Minnesota. Now, he was not on his way to work. The accident had nothing to do with work, but he had been to Minnesota pretty regularly for his job. And that, plus the Minnesota Supreme Court's conclusion that their own law was just better than Wisconsin's, caused them to think that they should apply their own law. The case went to the Supreme Court to decide whether anything in the Constitution stops the state of Minnesota and the Minnesota Supreme Court from deciding that their law is just better than everybody else's and applies even to things that have almost nothing to do with their state. And the Supreme Court turned down any opportunity to play the role that Professor Laycock, I think, agrees that they should have played. As the plurality opinion by Justice Brennan said, it's not for this court to say whether the choice of law analysis that the Minnesota Supreme Court adopted is correct or whether we would do the same thing. All we're supposed to do is decide whether anything in the federal constitution stops it, and they concluded nothing in the federal constitution did. And this is pretty much where things stand today. When it comes to one of the most fundamental questions of interstate relations, if a state Supreme Court wants to apply their own law to almost anything, as long as there's any imaginable connection, the U.S. Supreme Court will let them. But this is not just an area of deference. This is not just an area where the Supreme Court leaves everything up to the states. Last year, in a case called Franchise Tax Board versus Hyatt, the Supreme Court had a very different question of interstate relations, or at least what they thought was a very different question, which is whether or not one state, in this case the state of California, ought to be able to claim sovereign immunity in another state's court, in that case the state of Nevada. So this too is a question of interstate relations. One might even call it a question of choice of law. The Nevada Supreme Court sits over here deciding whether or not it can hear a case against the Franchise Tax Board of California. They conclude that the answer is yes. California doesn't like this answer, so they go to the U.S. Supreme Court. If we were applying the same kind of deference the court applies in choice of law, you would expect the U.S. Supreme Court to say, no, this too is just left beyond the Constitution to handle. But that's not what the Supreme Court said. Instead, the Supreme Court stepped in I think we could call a Lacockian fashion, to say this is an area where the Constitution controls it. There's nothing in the text about this. Again, there's nothing in the text that says which state's law applies in a multi-state conflict. But the Supreme Court said there are a lot of other provisions in the Constitution that talk about the states, that divest them of traditional diplomatic and military tools, that stop them from levying war, contracting alliances, entering duties and imports and exports, and so on. You heard a lot of them already in the previous presentation. And so the court said, the Constitution imposes on these states, as part of its transformation from a loose league of friendship into a perpetual union, a fundamental principle of equal states. And as a result, there are doctrines of federal law that now control things that previously were left to the raw power of the states. So in one area, choice of law, the Supreme Court says there's nothing, almost no constraint on what the states can do. In another area, sovereign immunity, the Supreme Court says, no, actually rules of federal law announced by the Supreme Court, essentially constitutional law, will control this. This seems to me to be the worst of both worlds. I would be reasonably happy living in Professor Laycock's world, where the Constitution and the Supreme Court doctrine controlled everything, all questions of interstate relations. This is not an area the states can be left to solve on their own, and the Supreme Court is as good a neutral arbiter as we have these days. I have some textual misgivings about the approach. I'm not convinced that the principle of full faith and credit does quite as much work as we might want it to. On the one hand, it says that all state laws are entitled to full faith and credit. That sounds like nothing could be more than full faith and credit. But on the other hand, it says that Congress is allowed to decide what the effects thereof are. So maybe the question of what the effects of those laws should be left up to Congress. But and I would like it better if there were textual provisions that talked about the territoriality of the states and some of these crucial principles. But again, I'd be reasonably happy living in that world. It does lead to some practical problems, however, and these are some problems the courts have faced in the past. So principle of territoriality on its own won't tell us questions like what happens when a conflict affects more than one state, when an accident involves somebody driving from one state to another, or people from one state and an action that takes place in another state. So besides the principle of territoriality, you need what conflicts nerds would call a principle of localization, which is to say a principle that tells you, well, what's the act that really matters? The Supreme Court did briefly experiment with constitutionalizing that But it was back in the Lochner era when the Supreme Court could say, using a sort of complicated doctrine of vested rights, that your constitutional right to have a particular state's law apply vested under the Due Process Clause as soon as a particular act happened. Most of us don't really think the Lochner era is something we totally want to return to, and unless we do, I'm not convinced that a constitutionalization of the law of choice of law would be possible. But it's interesting, right now we live in a sort of a strange world in between, where the Supreme Court is sometimes trying to constitutionalize principles of interstate relations, as it does in the sovereign immunity context, and then other times continuing to abdicate them, as it does in the choice of law context, which is much, much more important. And so we ought to either go all the way, I'd call that giving into the dark side, and letting the Supreme Court create some kind of constitutional law to solve all these problems, or try to find some other way to be free from that, which perhaps Professor Sachs can tell us about.
Thank you, Professor Bode. Our final speaker is, as Professor Bode mentioned, is Professor Sachs, who is a professor at Duke University School of Law. He teaches civil procedure, constitutional law, legal history, and conflict of laws. He joined the Duke Law faculty after practicing law at Mayor Brown in DC. His research interests include federal jurisdiction, constitutional interpretation, sovereign immunity, and the legal status of corporations. And he did 2 clerkships before joining the faculty with Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit and with Chief Justice John Roberts. I will turn it over to Professor Sachs to clear everything up for us.
Thank you. I'm not entirely sure that I can clear everything up, but I want to note the strangest thing about the Constitution and interstate relations is that you have these 13 states that are living cheek by jowl, and yet the Constitution actually says very little about what rules they're going to be governed by. It doesn't say very much about what happens to govern state borders or personal jurisdiction or choice of law problems. It speaks in very general terms. And I think there's an explanation for that. And the explanation is that the Constitution was not the only game in town. The founders didn't think that they were setting out any sort of detailed code to govern interstate relations. Indeed, they thought they had the rules they needed off the shelf, in a sense, just not happening to be found in the Constitution. Instead, the rules of general and international law that governed relations among sovereign states generally would also govern relations among the new states of the Union unless they were set aside by the Constitution or by federal law in some way. So to see how this works, let's think about the case of state borders. So we've got all these states. We know they have border conflicts. The Constitution talks about this. It mentions in the Territories Clause that nothing in the Constitution can be so construed as to prejudice any of the claims of any of the states. So it knows that there are active border fights going on. You would think that in an agreement between all the states of the Union, that would be an important thing to settle. They'd want to know where exactly the states are. Nonetheless, they don't settle it. And instead what they do is they create institutions to settle it rather than laying down specific rules. So if you have a question of state borders, let's say the river moved in some way, and we have to ask, well, is this an avulsion such that the border stays where it is, or a slow accretion such that the border follows the river in some way? You're not going to find that rule in the Constitution. No matter how closely you stare at the word states, you're never going to be able to find the detailed rules of riparian borders. What you can know, though, is that questions like this would head to a neutral arbiter. So you can have Article 3 jurisdiction for suits between states, where one state can sue another on questions of territory. You also have Article 3 jurisdiction for diversity cases, if someone is living in one state and another person's living in another. You have Article 3 jurisdiction for non-diverse cases arising from land grants from different states. When two states purport to grant the same piece of land, that case can get into federal court. And so what you have essentially is a way of solving these problems that does not require the Constitution specifying the rules. But okay, the case goes to federal court. Well, what is the federal court going to do? How is it going to decide? And the answer is that it would call on existing doctrines of general and international law. You may remember from covering Swift v. Tyson and Erie that at the founding and up through the 1930s, there was an assumption there was this thing called general law that all of the states, in some sense, had access to in the federal courts as well. It was not law of any one state or law of the United States for federal question purposes, but it was law for the United States, as Judge Fletcher has put it, law that United States courts could invoke in cases that required it. And so there were general law rules about riparian borders and international law rules that might settle some of these land grant cases. And if you look in the early Supreme Court cases involving state borders, those are the kind of rules that they actually applied. Now, today, we would probably call these either constitutional rules, which is sort of iffy, or federal common law, which is also iffy because it doesn't seem like a category like federal common law existed for the first 150 years of the Republic. But what's particularly interesting is we can be pretty sure that it wasn't federal common law in the sense of creating federal questions, because otherwise this non-diverse land grant jurisdiction wouldn't need to exist. Every one of those cases would have in some sense posed a federal question, but that's not how the framers thought of it. They didn't think of this as federal law. They thought of it as just general and international law, which the federal courts could apply when a question involving it came up. Now, why would they do this? Why would they allow that sort of law to govern? And the answer is, in certain ways, the federal courts are sort of an international tribunal. If you think about, the tribunals that might exist to solve land disputes among sovereign nations, all the states had gotten together. They were under the Declaration free and independent states. They were just sovereigns that had chosen to act together for certain fashions. In the Articles of Confederation, they confederated and gave certain powers to the central government, but they reserved all powers that weren't expressly delegated in that way. And in the Constitution, too, the 10th Amendment drops the express language, but the general assumption is that whatever the Constitution doesn't touch, it leaves alone, and the states retain the powers they had before that are not given to the federal government or prohibited by the Constitution to the states. And that includes a lot of the ordinary rights of sovereignty to own land and such. And so when a question of state borders comes up before the federal courts, they deal with it the same way they would deal with the dispute between the United States and some other foreign sovereign, or if somehow Minnesota and Canada had a border dispute, the same kind of principles would apply. You see this also in areas like choice of law and personal jurisdiction. So borders generally determine the scope of a state's executive jurisdiction, where its officers can pick you up, not across the state line. Choice of law deals with the state's legislative jurisdiction, where how far does the legislature's writ run? At the founding, the full faith and credit clause wasn't, in my view, construed to say quite as much about legislative jurisdiction. They sort of assumed that there were rules about that, but they didn't attribute them to the full faith and credit clause. Instead, the full faith and credit clause was generally interpreted to do relatively little. The self-executing sentence really addressed only the effect of state documents in other states, the evidentiary force that they carried, and any substantive effect was to be determined along with the manner of authentication by Congress. Indeed, Congress in the 1790 Act didn't even specify the effect that sister state acts would have, even if, and this is a disputed if, it determined the effect that were owed to sister state records and judgments of other sorts. Instead, the questions like Allstate versus Hague would generally have been dealt with through removal. So if you have, Mr. Hague, who's from Wisconsin, the Allstate Insurance Company, which is not, that case, assuming that Congress permits it, could go to federal court. And the federal courts, not bound by the errors of Erie and Claxon, would be able to apply their own general law rules of choice of law. I mean, you look at Story's commentaries on the conflict of laws, choice of law was seen as a field of general and international law, which the federal courts, as you'll remember from Swift v. Tyson, could take an independent view. They would not be bound to whatever the Minnesota courts thought about this international law question. They could deal with it on their own, in their own way. And so that the problem would be solved not by a constitutional rule, not by sort of Lochnerizing all of choice of law, but just by moving those cases into a neutral forum, namely the federal courts. And then on personal jurisdiction, sort of why should Minnesota have the case to begin with? We're used to thinking of personal jurisdiction as a question of 14th Amendment due process. But of course, the 14th Amendment wasn't there for the first 100 years after the founding, or 80 odd years. And the nonetheless, they had lots of personal jurisdiction cases. So how did they deal with them? The answer is they dealt with them through rules of general and international law. The state issued a judgment, and that judgment was seen as beyond its powers as a sovereign, the same way if France issued an exorbitant judgment that nobody else thought was within its powers as a sovereign, other states would simply ignore it. They would say that's not entitled to any effect under the full faith and credit clause because it doesn't have adequate international jurisdiction. And as a Supreme Court case reaffirming this practice in 1850, Darcy v. Ketchum said, we look to the international law as it existed among the states in 1790 and try and see if the Constitution or if Congress did anything about it. And on this topic, they said no, they just left it alone. And whatever the international law rules are, those are the rules that govern the powers of state courts vis-a-vis one another. What the 14th Amendment added was not, again, a sort of Lochner-ish constitutionalization of all of this, but rather it federalized the issue by creating a federal question of what had previously only been a general law question. Again, think back to Swift v. Dyson. General law questions are not questions of federal law. It's not preemptive. They have to have some other hook like diversity to get into federal court. But after Pennoyer v. Neff, what the court explained was that, look, if you don't have jurisdiction, then your judgment isn't really valid. So if you try and take away someone's property under that judgment, that's a deprivation of property without due process of law, without a valid legal judgment to back it up. And so now, if someone wanted to argue that a state court lacked personal jurisdiction over them, they would say, hey, if you go ahead and execute this judgment, that's going to be a due process violation. And so therefore, I can appeal from the state Supreme Court up to the US Supreme Court and get review of your personal jurisdiction. And now the state courts have to listen to what the federal courts think about the general law topic of personal jurisdiction, or else be reversed on due process grounds. Now, that's an extremely complicated setup, and it is not at all surprising that within a generation or two, law students were just being taught due process is the topic under which personal jurisdiction is governed, and the whole Rube Goldberg setup sort of faded away. It became just a topic in due process jurisprudence, as we've now seen under International Shoe and its progeny. But in fact, the actual source of the rules was not, people staring really hard at the words due process of law and figuring out lots of stuff about in-state service and minimum contacts and so on. The actual source of the rules were pre-existing rules of general and international law that, in my view, continue to operate until Congress, within some enumerated power, is able to set them aside. So again, the take-home point is the Constitution assumes the existence of rules to govern questions of interstate relations, but it doesn't supply those rules. Instead, it expects that we'll look either to rules enacted by Congress within its powers or to rules of general and international law.
Thank you, Professor Sachs. So now I would like to encourage all of those listening to think about questions that could be posed to our panelists. My understanding is they will pop up on my screen, and I would be happy to ask the other panelists some of those questions. In the meantime, while all of you think about these thought-provoking presentations, I'll ask a couple of questions of my own and hopefully open it up to panelists. I think I don't know that I need to call on anyone in particular. I would normally just open it up to whoever wants to answer it. But the first question I have is a practical one, which is the place where the United States Supreme Court has done a lot of work on interstate relations is obviously those cases that fall within its original jurisdiction, land disputes between two states, not just two citizens of other states, but actually two states. Are there any lessons that we can take from how it's performed in those areas, or frankly, any of the areas you've talked about, on how equipped federal courts, and specifically the United States Supreme Court, is to deal with questions of interstate relations?
This is Will, and I'll jump in with two possible lessons. So one is, and I think it's right, this is a sort of not very widely studied area of the Supreme Court's docket, unless you teach water law or contract law or a couple of areas. But every year there's something on the Supreme Court's docket that involves, Kansas versus Nebraska or some other set of neighboring states fighting about a river or an island or something like that. My own impression from those cases are two lessons: one optimistic, one pessimistic. So the optimistic lesson, especially for something like Professor Sachs's view, is that the court does seem to take a kind of background principles, general law approach to a lot of them. It sort of assumes, well, there's some kind of principle that governs where this border goes. We don't just as justices get to kind of make it up on our own, right? They're not taking advantage of the fact that they can hear this case to decide, just as a matter of policy, who ought to own Ellis Island or what they ought to do with some piece of river. They seem to think their job is to preserve some kind of stable expectations, to make the federal system run smoother, to apply whatever law has been in place for a long time if they can. That all, I guess I'd say that sounds good. Like if we could take the Supreme Court's performance in those cases, it'd be about what we'd hope for from a federal tribunal in charge of interstate relations. That's the good part. The bad part is, from what I can tell, the Supreme Court does not like these cases very much. So when they hear the cases, and maybe this is partly a necessity, but when they hear the cases, they generally appoint a special master who is not one of the justices to be in charge of most of the case, including fact-finding, negotiating with the parties, managing a lot of the procedure. And then they, as a court, kind of check in on the case every couple of years when the parties have some sort of problem. So the Supreme Court is exercising oversight over the case, and if there's a legal issue, they ultimately do, resolve it and have oral argument and write an opinion about it. But for the amount of time the case spends sort of supposedly in the Supreme Court, it spends most of its time in front of a temporary employee of the Supreme Court, where the justices don't have to be very concerned with it very often. And, while, again, there are practical reasons for that, I do get the sense it's not an area of the Supreme Court's docket where they think this really deserves their attention. And then the other place this is even more starkly apparent is the Constitution and the federal statutes about the Supreme Court's original jurisdiction might lead you to believe that when two states have a dispute about something, they are entitled to bring it to the Supreme Court. The Supreme Court has jurisdiction. No other court has jurisdiction. And the normal practice in jurisdictional rules is that when a federal court has jurisdiction, especially when nobody else does, and somebody shows up and sues, the federal court puts it on its docket and deals with it. Maybe through a motion to dismiss, maybe through a motion of summary judgment, but they deal with it. The Supreme Court has created a doctrine where they decide whether they want to deal with it. And even though, again, if they say no, there's nothing else for the states to do, the Supreme Court regularly just declines to hear cases between two states. Justice Thomas and Justice Alito have very recently started objecting to this practice, but they're the only ones. So in addition, even if the Supreme Court agrees to hear a case, they don't really necessarily hear it very much, and they reserve the right not to hear it. So the good news is when the Supreme Court hears these cases, it seems to do a decent job. But the bad news is they don't seem super eager to spend their time and energy on it. And that makes me a little nervous.
Any others want to respond?
So one point that I think is worth making is that the Supreme Court might do a better job at these cases if the federal courts were deciding cases like this too. So if interstate relations is taken as something that's either always constitutional, and so generally, goes right up to the court from state Supreme Courts that are reviewing its work, or alternatively is entirely, up to the states to decide, then you have this sort of all or nothing quality. Either the Supreme Court gets its hands dirty or nobody does. On the other hand, if the assumption were, look, we're going to provide for very broad diversity jurisdiction, very broad rules of removal, and thereby allow federal courts to deal with lots of interstate relation cases, maybe the Supreme Court would have less new work to do when it's deciding these issues. I totally agree with Professor Bode as to the original jurisdiction. The court sometimes likes quoting the Marshall line that, when we have jurisdiction, we're sort of required to exercise it, but they don't actually carry that through very often. And I hope, though I would not expect them to do that more, I wonder actually if they created if Congress created some permanent body to act as sort of a team of special masters rather than having one-offs, if the court might be more willing to let the cases come in, as I think actually is its obligation when the plaintiff shows up with a complaint asking for a remedy, that they have to decide whether or not they are entitled to that remedy. Maybe if the court were assured that people who actually know this stuff will be doing it on a regular basis, they'd be willing to do a little bit more of their jobs.
This is Doug Laycock. I agree with most of that, but I think the problem with the disputes between states. Are we on?
I can hear you.
Okay. It's not that these are disputes about interstate relations, it's that they're the original jurisdiction. And the Supreme Court is not set up to be a trial court. It's not set up to find facts. And the facts in the boundary cases often are very complicated. The facts in the water cases are nearly always very complicated. And so to function at all, of course, they have to send this out to a special master. If they were trying to administer a neutral system of federal choice of law rules, it would be the appellate jurisdiction. They'd be getting these cases from states and from lower courts. And as Professor Sachs just said, if the federal courts in diversity could do part of this, there would be neutral arbitrators below the Supreme Court level. The Supreme Court has eliminated that possibility by holding that federal courts in diversity have to follow the state choice of law rules. And some state courts do a better job than others, but fundamentally in these choice of law disputes, the state courts are not neutral, right? If the forum has some preference for its own law, it has greater familiarity with its own law, it has some natural tendency to prefer its home state litigant, the federal courts are the only potential for a neutral source of choice of law rules. And I agree with, I think, what both the other two panelists said. Those rules are not in the Constitution themselves, but I think the Constitution does require courts to apply them. They're a background body of rules that the founders assumed, and that I think federal courts should be developing.
Just to jump in with one more thought, I think both Professor Sachs and Professor Laycock make the point about sort of lower federal courts and diversity, which I think is very helpful and very illuminating. But again, the one thing to worry about, and I hope Judge Strass will take the Fifth Amendment on this one, is my sense is that federal judges these days do not have a lot of enthusiasm for the diversity portion of their docket either. It's not a very large set of cases. It tends to be, common law questions rather than the federal law questions that a lot of federal judges are more expert in. And there are a lot of issues in how federal courts handle those too. And I think we all agree about that, and part of what we need to see for this kind of regime to work would be a sort of fundamental change in what federal courts think about their job being. And we need to see them see diversity cases as a real important part of the job, and see the Supreme Court change doctrine to let them actually, do that job. But that means that this is a sort of a big intellectual shift or a big institutional shift we need to see happen, and not something that could easily just happen tomorrow.
To respond a little bit, I'm going to mostly take the fifth with respect to what Professor Bode said, but I will say that there are judges that have different degrees of enthusiasm for the diversity portion of the docket. I am actually one that has a little more enthusiasm, but that's because I spent 7 years of my life on a state court, so I saw a lot of those things before. But it is something that I think federal judges can do a better job at, is dealing with some of these cases and providing some guidance. Because I do think it's an important historical part of our docket. So I think that Professor Bode is absolutely right, and that we can all do a little bit better on that. We do have a question, if I can bring it up here, from one of our viewers, which I think is fascinating. I'm going to combine it with a question that I was going to ask, which is, we're facing, in a global environment, we're facing new issues than we used to. Certainly from state to state, but even globally as well. And so one of our listeners is asking, what horizontal federalism concerns do we have, and talk about a timely question, with respect to coronavirus? States exercising regulation outside of their borders, things like that. Are there lessons we can take historically or from things that have happened over time that can help us understand what the limits of state authority are in this context?
Well, we may soon see states barring interstate travel. No one can come into New Jersey from New York City. And I guess my reaction to that is, either such rules have to be laid down by the feds, or they have to be justified by something like a compelling government interest, which may well exist here. But we've got the Articles of Confederation had express clause about ingress and egress between states. The Constitution doesn't have that, but of course the Supreme Court has found a right to travel, and I think that's implicit in the right to be treated as privileged immunities, the right to be treated as a citizen in sister states. So restrictions on interstate travel are highly suspect and may soon become very appealing as this thing gets worse.
Professor Bowe,
But in a
Professor
lot of
Sachs,
ways,
you want
that's
to
a
jump in?
dormant commerce clause question. And we see some. Oh, sorry. I was going to say, in a lot of ways, that may be a dormant commerce clause question. The scope of one state's ability to restrict, trade and traffic across state lines. What's interesting, if you look at Gibbons versus Ogden, some of the early dormant commerce clause cases, they assume that inspection laws, health laws of every description are going to be subject to state control. They don't say exactly how much that is, and this is not a well understood area of law. It's certainly one that's been in flux recently with regard to tax jurisdiction and other things. This too is an area that has never really been reconciled with choice of law. So for instance, there are cases holding that states can't try to regulate the internal affairs of other states' corporations, not under the full faith and credit clause, not under the due process clause, but under the dormant commerce clause, though that's not necessarily the best home for them, since you can create a corporation in Delaware, even if all of the shareholders are here at home in New York and all of its operations are in New York and so on. But that area of jurisprudence is always very heavily litigated, and I would think most of the COVID cases would come under that heading.
On your point about the dormant commerce clause, there's a case towards the end of the Depression, I'm blanking on the name, but California tried to ban the in-migration of poor people from sister states, and the court struck that down under the dormant commerce clause, rather than the right to travel or privileged immunities or something else.
All right.
This is just one thing to add, which is I guess I think this is one thing that happens in these areas is that all the principles end up moving around just sort of one clause to another. So sometimes something becomes a dormant commerce clause question, then it becomes a full faith and credit question, then it becomes a due process question. And so the modern doctrinal categories end up kind of taking the baggage of these old areas. I guess one other area we're seeing some interstate activity is we've seen Massachusetts start to recognize more professional licenses from out of state to make it easier for healthcare workers from other states to sort of come in and help out. That's an area where states sort of voluntarily, at least sometimes, seem to be doing something helpful. But you might imagine in a fully Laycockian world that a state wouldn't even have to do that. That there'd be some constitutional principle that would make it easier for interstate recognition to sort of happen automatically.
Just to kind of leverage off the point we've been talking about, we've talked about regulation and the challenges from the coronavirus, but are there other areas? The Constitution, as we know, was written over 200 years ago. Are there other areas of interstate relations where the Constitution is not particularly well equipped to deal with interstate relations or conflicts that arise between states?
So if I could jump in, I think the issues, at least from my perspective, are less ones of constitutional law than of general and international law. And there are certainly plenty of areas where technology and other kinds of changes have moved faster than general principles have. So if you think about questions of internet jurisdiction, if someone hacks into your bank account, where did that act take place for either personal jurisdiction questions or choice of law questions? I live in North Carolina. My bank account was originally created in Connecticut. The hacker could be from, Russia or somewhere. and we have the question of whose law governs and determines the penalties is one that could have been faced in certain ways under prior regimes, but not necessarily. If you look at Story's commentaries on the conflict of laws from 1834, there's no chapter on torts. He doesn't talk about conflict of laws for torts, probably because most torts at the time would definitely have been governed by the law of the place where the tort occurred, and that it wasn't very interesting. You don't need choice of law to tell you, whose law governs a bar fight unless the bar is located, right in Texarkana on the state border or something like that. You only need it to govern cases where there are lots of weird foreign facts. And so certainly the increasing commerce between states and with foreign governments means there are just more cases with weird foreign facts now than there used to be. That, again, might be an argument, though, for more aggressive congressional intervention. If Congress has the ability to regulate cross-border communications and cross-border activities, it has the ability to specify under the effects clause of Article 4 which state's law will govern various topics, it maybe should do so rather than leaving the courts to figure all of this out on their own.
I agree with that. Congress isn't interested in it either, and there are no votes in it. The people who are disadvantaged by discriminatory jurisdictional or choice of law rules are not and never could be an organized interest group. So there's nothing in it for Congress, but Congress plainly has a responsibility here. And pretty much all it's done for 200 years is copy the language of the full faith and credit clause into a statute.
All right, I'm going to jump in here with another question. One of the interesting things that I think when you contrast, and it was brought up by several panelists, and I think the compare and contrast here is interesting. When you talk about long-arm statutes and personal jurisdiction, for the most part, the Supreme Court's been very active, and federal courts have been very active in limiting the ability to bring to hail people from foreign states into the plaintiff's home state. But when you talk about choice of law, and it may have been Professor Boat or Professor Sachs, I can't remember which, said, for the most part, there really isn't much of a limitation on choice of law. The court's been pretty hands-off on choice of law, but been pretty robust, especially recently, on enforcing personal jurisdiction and not allowing states to extend jurisdiction and sort of minimizing the effect of long-arm statutes. Any reactions to that? Why do you think there is that difference?
I don't know. I've puzzled over that for a long time because these are very closely related, both in terms of the traditional general international law and in terms of the Constitution. And the full faith and credit clause appears to apply both to judgments and to substantive law, but the interpretation has been radically different. And so the Supreme Court says judgments from a court with jurisdiction are binding or entitled to full faith and credit everywhere, even if they offend the public policy of the receiving state. No exceptions. You got to enforce the judgment. But we will make the rules for when the first court had jurisdiction, and we'll enforce those rules. As you say, they've been pretty active recently. They've been cutting back. And the body of federal law about choice law is at the polar opposite. States can do anything they want. Now, one way to think about that is they're trying to police it all with jurisdictional rules, right? If the state gets jurisdiction, then it can prefer its own citizen or its own law or do whatever it wants, but it may have a hard time getting jurisdiction. I don't think that works very well, but that's one way to understand what the court's done. But this difference in treatment starts with the New Deal court at the end of the Wagner era. And I think, whoever said this was part of Wagner, I think it's a very different kind of issue from economic substitute due process. But that's how the New Deal court viewed it. They got out of the choice of law business at the same time they got out of economic substitute due process. They did not get out of the business of policing jurisdiction or requiring full faith and credit to judgments.
I think that one possible explanation might be that. Oh, sorry. Go ahead. So I think one possible explanation might be that the policing of choice of law rules requires a lot more work than the policing of jurisdiction. If you're going to police choice of law rules, you sort of need to develop a whole choice of law code. You need to, proclaim the first restatement of conflicts as the requirement of the due process clause. You can't just do it. You can't just sort of trim the outliers, or at least it's harder to do so without a theory of what makes them outliers. Whereas in jurisdiction, it's a little bit easier to do so. You don't need to determine jurisdiction in every case to say, well, this judgment was valid and that judgment wasn't. And second, sort of more doctrinal reason is that due process functioned differently in personal jurisdiction cases than it did in conflicts cases. So in a personal jurisdiction case, the way Pennoyer worked was that they would say, look, if you're planning to take away somebody's liberty or take away somebody's property on the basis of a judgment, and that judgment is not, in our view, valid under the general and international law rules, then you're depriving them of property without due process of law. And so that's a violation. We can correct that on appeal by vacating or reversing the judgment. But if the court had jurisdiction, then the choice of law issue is just a question of whether it was correct in applying a question of general or international law. The result was a judgment that might be erroneous, but was not void. And the ground on which it was erroneous was not a federal ground. It was not a federal question of choice of law. The Supreme Court had intervened to say that full faith and credit, under the full faith and credit clause, it said that you had to respect the judgment of another court when that judgment was rendered with jurisdiction. But it had not done so for choice of law. Indeed, because the 1790 Act didn't even refer to it. Acts wasn't even in the statute until 1948. So there was no ground on which to reverse a mistake of choice of law, the way that there was a federal ground on which to reverse a lack of personal jurisdiction.
So I was going to agree with a lot of what Professor Sachs just said about choice of law seeming harder to solve, or at least harder to make sort of interstitial contributions in, unless you figured out a way to really solve it. If I had one kind of cynical materialist explanation for that, it might just be that civil procedure is a required course in law school and conflict of laws is not. And so all judges have developed at least some intuitions about personal jurisdiction at some point in their life, depending on how much civil procedure they studied. But it's possible the choice of law could just seem like one of those really hard subjects that somebody else should take and figure out. So maybe one solution would just be to require choice of law as part of the first year civil procedure curriculum. Maybe that would help a lot by itself. But it's also possible that this will change. So I actually have two former students from my conflict of laws class who are now looking for a test case to litigate the unconstitutionality of interest analysis along the lines that Professor Laycock referred to. That is, they're looking for a case where they can say, here is a state Supreme Court that applied their own law to a case or applied different law to a case, clearly to disfavor an out-of-state person. That is, they would have applied better law in favor of an in-state person, and they're applying worse law purely because this person is out of state. It is hard to find a good vehicle for such a case because the choice of law doctrines are now so murky, and because so many, every case has its own facts. It's hard to find a case where you can very clearly say, here is where the discrimination is happening, even if it's totally clear that choice of law doctrine sort of requires that discrimination to happen. But maybe if they can find one, or maybe if some cooperative state Supreme Court will be honest to what it's doing, we could actually have a vehicle to see whether the Privileges and Immunities Clause can do any work here.
I think there's a lot of force to what Will just said. And, it's not just that, lots of judges didn't have to take a conflicts course. Lots of lawyers didn't either. But also the history is so disastrous. So the first restatement of conflicts is discredited, and for good reason. He tried to derive all rules from a single principle about the law of the state where the last act necessary for the right to vest happened, and it just didn't work. In my view, the problem was not that he tried to make territorial rules. He made terrible, stupid territorial rules. The reaction to that produced a period of kind of chaos in which there were all these academic theories floating around and courts adopting some of them. And they were all inconsistent with each other and different courts doing different things. And then to a surprising extent, whatever they said, territorial intuition still doing a fair amount of work. And I think one of the reasons Professor Bode's students are having trouble finding a test case is, a lot of courts wind up sort of drifting back towards territorial results, whatever theory they announce. And so in the academic literature, there are all these clear cases in which a court winds up saying, I rule against you because you're from out of state and I get to prefer my own citizens. And there's some of that in the real world, but there's much, much less of it in the real world. So finding a case where unambiguously that's what happened may take a while to find. But the academics have not served the field well, and the first restatement certainly didn't serve the field well. There's now a third restatement underway. I don't know how it's going to turn out.
I'm not optimistic about it. One of the things I tell my students in conflicts is that there is no area of law in the 20th century where academics have had a greater influence than conflict of laws, and probably no area of law that is more messed up. And it's probably not a coincidence. And now, I will say, so, and Professor Sachs mentioned Joseph Story's conflict of laws, and I think if we see that as the sort of the 0th restatement, the original restatement, we could have done a lot better by sort of trying to stick with that. So Story had a set of territorial rules, but they were described as principles of general international law, and so they were more flexible. There wasn't as much of an attempt to make them kind of Platonic axioms where there was one unique answer to everything, which then forced the first restatement into weird epicycles about, what exactly to do if you were poisoned and traveled across multiple states while the poison took effect and all sorts of other weird things like that. So people rightly thought the first restatement had gotten sort of too much. But then rather than do something sensible, like go back to the 0th restatement and kind of loosen the territorial rules up a little bit around the edges, they instead decided we need to do away with territory altogether. And you can read all these 20th century law professors saying, the fundamental problem with choice of law is that borders are arbitrary and therefore law should just have nothing to do with borders. But as long as we have borders, they do a pretty good job of deciding, which side of the line California should be on, which side of the line Nevada is on. We've got a line, and California's on one side, and Nevada's on the other. So I worry there was sort of an overreaction against borders and lines and artificial things altogether, and we're still basically paying the price for that overreaction.
And now that we mentioned the first restatement, the 0 restatement, and the third, for students who are wondering, what about the second? The second tried to be all things to all people, tried to mix together all these academic theories and generally produce mush. So some people like it better than I just described it, but pretty much the first 2 restatements are both discredited.
All right. While we are on this topic of, and Professor Bode, you gave a great segue into one of the questions from our viewers, one of our viewers, which is take that point you made about the lack of borders or onto jurisdictional questions. And this particular listener says, is there a point in which states should not be treated as separate sovereigns in deciding jurisdiction? And he mentions, and we touched on internet cases, corporations, and other instances as well. In a global national economy, and I just actually wrote an opinion that was published last week about virtual contacts, and when virtual contacts over email are enough to give you personal jurisdiction. What's your response to a student that might be struggling a little bit with how to do personal jurisdiction under current conditions?
Well, I think current conditions are going to be difficult, whatever the set of rules are. Right? And the internet. Go ahead.
Professor Sachs? Oh, go ahead. I think we've got a little bit of delay. Professor Sachs, do you want to go, and then Professor Laycock? Professor Sachs, do you want to go, and then Professor Laycock?
Sure thing. I was going to say that current conditions are difficult to look at. That current doctrine is quite complicated and not exactly what original doctrine would have looked like. Trying to figure out under the effects form of contacts under Calder-Jones and Walden, trying to get a sense of when conduct in one jurisdiction counts as a contact somewhere else. If you look back at the earlier literature, there really isn't a whole lot in terms of contacts. Minimum contacts essentially emerged out of the doing business test that affected corporate jurisdiction, not the kinds of things that individuals might be engaged in. So if I, as an individual, had an agent who was not an agent for service of process somewhere else, under the Privileges and Immunities Clause, I had a right to do that. The state couldn't condition my ability to enter contracts in another state or do other things in another state. And so they couldn't force me to consent to jurisdiction in quite the same way that in cases like Lafayette Insurance Company versus French, they were held to be allowed to condition corporations whose existence depended on being recognized by state law. So of old, most individuals only could be subject to jurisdiction where they were or else where they were domiciled, and not necessarily when they had contacts elsewhere. So, defaming someone via email would not necessarily have subjected yourself to jurisdiction in that foreign place. Whether those are the right rules for today, it's not entirely obvious. But again, this is one of the things that the Constitution lets us fix with institutions. So if Congress wants to say, hey, look, you defame somebody over email in a second state, you guys are diverse. You're from one state and they're from another. And so you can take that case to a federal court, and then it's just a question of venue, where we decide to put the courthouse. That's a lot easier, and that makes it much less high stakes than a question that goes to the power of the court, either one state's court or another, and a jury and a judge appointed by or elected by the people of one state or another have to be able to solve that problem.
Yeah, it's somewhat lower stakes, but the geographic burdens are still enormous. And the interstate cases, the internet cases would be hard under any system of rules. So if I go on Amazon and buy a book, maybe Amazon will ship me that book out of its own warehouse, but quite often it turns out I get that book from a small dealer someplace. So we got a small dealer in California and I'm in Virginia, and neither one of us did anything out of state except interact with Amazon. If we wind up in litigation, fortunately a book is not worth suing over, but if we wind up in litigation, it's a hardship on one of us no matter where that litigation occurs. And whether it's in federal court or state court, if I have to go to California or the dealer has to come to Virginia, that's a problem. And when he posted on Amazon, he not only reached into Virginia, he reached all around the world. So those are difficult cases. Moving to federal court helps by giving you a neutral arbiter, doesn't help solve the geographic burdens. And, courts are struggling with them on the jurisdictional issue. And if we took choice of law seriously, they'd struggle with them on the choice of law issue too.
All right. So we've got a broad question from one of our listeners as well. Matt asks, is there any relevance to state gun laws here, the Second Amendment, and the treatment of how horizontal federalism will treat some of those issues? Any thoughts on that question? Those issues?
So this actually,
any thoughts on that question?
This actually became an issue because Congress has been talking about reciprocity for state concealed carry permits and so on, such that you could carry a gun if you have a license from one state into another state. This is often a problem because people don't realize if they got a permit from one state, they drive across the border and then get pulled over and don't realize they were doing something illegal under the laws of the second state. Congress, the legislation that was proposed would regulate this under the Commerce Clause on the theory that the gun had previously moved in interstate commerce and therefore was something that Congress could regulate. David Engdahl has called that the herpes theory of interstate commerce, that once anything moves across borders, it now has commerce and is forever imbued with federal authority. Another way of thinking about this, though, is that this is an issue. This is what the full faith and credit clause and the effects clause were designed for. Congress could, if it wanted, under the effects clause, provide for the effect of a permit from one state in every other state, and it could attach conditions or sort of regulate it in the way that it thinks best. But to on its own, the full faith and credit clause or the implementing statute almost certainly don't require interstate recognition of that form, but Congress could if it thought it wise policy.
Yeah, clearly Congress could regulate there. In the absence of a statute, I don't think. Yeah, clearly Congress could regulate there. In the absence of. I don't think we get to carry our home state law with us wherever we go. So in the absence of legislation, the constitutional solution is the state where you're in, their gun laws apply to the extent that they don't violate the Second Amendment.
All right, kind of along those lines, another one of our listeners asked early on, and I've been holding on to this question because it's also a pretty broad one, which is, does the Constitution itself place strict territorial limits on each state's power to regulate conduct? And we know with respect to criminal law, the answer is largely yes, unless the crime passes state lines and is committed in multiple jurisdictions. But to what extent does the Constitution tell us how much a state can regulate conduct outside its borders?
So I think this is one of the areas where we've seen some of the disagreement between the panelists. I think we all agree that in many ways the Constitution seems to make some assumptions about states regulating things inside their borders. In criminal law, the assumptions are the most obvious, where the criminal fugitives clause says that people who commit a crime in one state and then escape into another can be returned, and so it has this assumption that you will commit a crime relevant to one state in that state and then need to be returned, rather than you could commit it from afar, and has all these references to juries that seem to presuppose it. But nothing in the Constitution ever actually says this. And then for civil law, there's even less to sort of go on. So I think the question here ultimately is, how comfortable are we taking things that the Constitution seems to assume and turning those into things that the Constitution requires? And this is maybe the sort of the broader question that ties in everything we've been talking about. The Constitution, I think, assumed a world sort of like Joseph's stories, where there were a set of pretty well-developed principles about which state's law applied to what, and everybody assumed that deviations from that were probably not going to happen and would largely be disregarded by everybody else. But now things happen in a lot more places, and all the principles we used to have pretty much been thrown out the window. And so the Constitution makes an assumption that's no longer true. And I tend to read the Constitution in a pretty formalist fashion. So I tend to think there's nothing in the Constitution that entitles federal courts to go back in and sort of make it become true. But I have some sympathy for people who read it the other way. Just one last thing on criminal law. There is a case that I also teach in conflicts called Skiriotes versus Florida, where it's not an interstate case, but where somebody in Florida went outside of the Florida boundaries into the ocean to hunt sea sponges with explosives or something. I forget the exact details, which was contrary to Florida law, and then were prosecuted in a Florida court when they returned. And the U.S. Supreme Court said, well, that's fine. There's nothing in the Constitution that stops Florida from prosecuting a crime that took place outside of Florida. So even in criminal law, this is not an area the Supreme Court exercises a lot of oversight.
Well, and we have some laws like that at the federal level. If you go to Thailand on a sex trip to have sex with minors, you can be federally prosecuted when you come home. But interstate, we don't have the same need for that kind of regulation, right? And if you go from Virginia to Pennsylvania and do something entirely legal in Pennsylvania, it's pretty problematic for Virginia to prosecute you when you get home. And we may see that issue on the abortion front before long. On the abortion front before long.
I was going to add that abortion is perhaps the main area where you could envision something like that happening, where a state might prohibit leaving the state with the intent to engage in conduct that would be legal in the state where you're going, but is illegal in the state where you're coming from, or any sort of preparations that you undertake in the state where you're in before leaving. I will note that you sometimes do have difficulties even applying what seem like very straightforward rules, like the vicinage clause, or rules about where the crime was committed. So Justice Story has an opinion on circuit involving an American sailor who fired a gun onto a ship that was flagged under the Society Islands, which were a group of Pacific islands, and injured somebody. And that was held to be a crime that did not take place on the American vessel. It wasn't the firing of the gun, but its impact on the person that completed the crime, and therefore the crime took place in the Society Islands. So even the vicinage clause would need to have some theory of what to do when somebody fires a gun across a state border and hits someone else.
The reference to abortion by Professor Laycock, I think, is quite right. That, and I think it's a broader principle here that's worth paying attention to, which is that a lot of the time in a lot of areas we kind of muddle through, in part because state laws are similar enough on enough topics that people care about that states don't really try to push it and do weird things like prosecute people for conduct that was legal in another state, or try to stop people from going somewhere and then returning. But then every once in a while we have an issue where it's such a hot button issue, and sort of such a moral issue that people fundamentally disagree about. The states sort of have different views and then try to stick to their guns, and that's where having a sort of principles of interstate relations would be really useful if we had them, and if we could develop them in sort of the low key cases and stick to them. It'd be easier to sort of turn on settled rules when we have the more controversial cases. So there were cases like this in slavery. There are a lot of slavery choice of law cases, where again the sort of system tended to break down, and led to cases like Dred Scott versus Sanford, which is partly a choice of law case, where the Supreme Court then felt compelled to come in and make up stuff to try to stop it. And to a lesser extent, during Prohibition, some of these are labeled as Dormant Commerce Clause cases, but there's a whole string of cases where the Supreme Court tries to wrestle with the question of sort of where is the alcohol and who gets to regulate it. And what if the alcohol is on a train passing through Kansas? Can Kansas regulate it? Or what if the train stops? Then can Kansas regulate it? What if you move it from one train to another? Some of these are cases decided under the wonderfully titled doctrine, the original package doctrine, where the Supreme Court tried to make the sort of package be the line about when a state could regulate something. But the whole thing happened because, again, temperance and prohibition was an area where we had these kinds of profound moral disagreements that the states are trying to work out. So it's basically something that we need to make federalism work. And then when we really need it, we discover we don't have it.
This has been an excellent conversation we've had, and I want to allow you all, the panelists, any of you, if you want to ask a question of any of your co-panelists. I've sort of controlled the program up until now, but have not necessarily given you a chance to ask questions. So if you have something that you want to ask a fellow panelist, please feel free to do so, and then we'll sort of move into sort of a closing statement of some sort so that we can close the program off. But I'll turn it over to you for at least the moment. And if any of you want to ask questions, feel free to pipe in.
So I have a question for Professor Laycock, which I've been dying to ask since reading his Columbia Law Review article he talked about, which is how would the territorialism principle work? Like how strict would it be, and how would we decide sort of which state something belongs to when it wasn't totally obvious? I mean, we don't have to get into bullets, being fired from one state to another, but the huge range of things that sort of seem like more than one state's involved. Like, do you have a vision of territoriality, or what?
I have some vision, and I recognize there will be hard cases under a territorial system. There are hard cases under any system that tries to actually resolve things. I guess there are no hard cases under the current constitutional rule because the state can do whatever the heck it wants. But I think I think many of the classic chestnuts of the conflicts course are pretty easily resolvable. The one the one real insight of interest analysis is that relationships matter, right? And so, you know, my wife and I are domiciled in Virginia. The relationship between us ought to be governed by Virginia law, even if we get in an accident someplace else or buy a piece of property somewhere else or whatever. Um, and rules that regulate conduct ought to be governed by where you're acting. And uh, just saying those two things will resolve an awfully large proportion of all the cases. Um, I think it is important to identify precisely what it is that the two states disagree about. Are they disagreeing about marital relations? Are they disagreeing about rules of the road? Are they disagreeing about something else? And then when you've specified that, it becomes not necessarily easy, but easier to locate it. Um, uh, I think I think territorial rules got a bad name from the first restatement, which did a terrible job of it, and then we kind of threw out the baby with the bathwater. Um, and it did become field day for academics for a while, and many of the academic proposals, in my view, um, flouted the principle of treating states equally and treating citizens of sister states equally. They started with the premise that, of course, you would prefer your own citizens, of course, you would prefer your own law. Um, so, so I think we eliminate a lot of academic possibilities, uh, and um, and we can resolve a fair number of cases pretty easily, and undoubtedly we're going to have hard cases. And firing the gun across the state line is a hard case, although it's likely to be a tort in both places. The internet cases are hard, as I said a few minutes ago. But I don't think a territorial approach is inherently more difficult than any other approach, really. And I think it does have the virtue of conforming to the fundamental division of authority between states.
I also had a question actually for Professor Sachs,
Sure.
which is,
I have
I know what you.
I also have a question actually for the SAC.
So,
Which is
the question for Professor Sachs is, I know how you feel about Erie, but in a world where we can't overrule Erie, at least not for a long time, what are we supposed to do in the meantime? Because it seems like much of what the correct way to think about things is, at least from your point of view, requires the wrongness of Erie. And so as long as Erie's around, how should federal courts best muddle through, or should they give up until the day of salvation?
Well, I think that the first step in getting help is admitting that you have a problem. The first thing federal courts can do is, lower federal courts at will could say, but for Erie, we would be able to do X, Y, and Z. But for the meantime, we have to do something else. I think probably that it would help if more questions were seen as things that are not actually answered by the Constitution should not be ascribed to the Constitution. I think that that's probably step one. It's probably easier to move things from the category of federal common law to general law once there's a recognition that the category of federal common law probably doesn't exist, than it is to move things from the Constitution to something else. And it's also probably less distorting, because if you have to find some textual hook in the Constitution, you might get some very strange answer as to the substance of the doctrine, which wouldn't happen if you were just saying, yes, we know this is an area of unwritten law, and we're just going to call it federal common law instead of having to call it general law, because, until the blessed day arrives and Erie is destroyed and the site sown with salt and Ichabod written over its gates and so on, we can't talk in general law terms.
If I can respond to that, I mostly don't want to get rid of Erie. I think the founders some of them believed in something like Erie, and more of them probably believed in something like the general common law. But by the time of Erie, the general common law become untenable, become inconsistent with how the economy worked and the number and degree of interstate transactions, and you simply, in my view, you cannot defend the kind of results that were going on under Swift v. Tyson, where you got fundamentally different answers to the same question depending upon whether the plaintiff filed in state court or federal court. And if he had a good lawyer, he would figure out where to file. I would get rid of Claxon, which is the follow-on case that says Erie applies to choice of law rules, and the federal courts of diversity have to apply the choice of law rule of the state. I think choice of law rules should be made by federal courts. They're the only possible neutral arbiters, or they should be made by Congress. But I would not get rid of Erie.
Professor Sachs, did you have any questions
One
for
point
any of
that I
your
wanted to make
fellow
is that
panelists?
getting rid of Erie would actually be less.
Professor Sachs, did you have any questions for any of your fellow panelists?
Oh, I just wanted to respond very briefly. I think getting rid of Erie would not be quite as drastic an operation as that, in part because you're absolutely right. By the turn of the century, more was being done under the name of Swift v. Tyson than Swift v. Tyson really allowed. So if you had, for instance, a state statute that governed this conduct, there was no question but that was one of the laws of the several states that would absolutely well apply. If you had a very clear state local usage, that also under Swift v. Tyson ought to have applied in preference to the general law. And nowadays, there's so much state statutory law and so little comparatively state common law compared to the Swift v. Tyson era that I think that the impact on ordinary state practice would be actually quite minimal. But in terms of the other panelists, one question that I have, and this is really just sort of for the panel in general as a matter of brainstorming, is what's the best mechanism for having this happen? So if the question is, how does one get Congress to act? What's the political economy story whereby Congress actually decides to deal with choice of law? Or does it, create some body like, the rulemaking process or something to govern this issue? Or if it's the courts, how do we solve all of these problems at once through litigation as opposed to legislation? I'm curious as to any thoughts folks have on that topic.
I don't have any answer to that question. Even before total gridlock and congressmen who refuse to speak to each other, there's nothing in this for Congress. There are no votes in it. There's no organized interest group on the part of individual litigants who get screwed by discriminatory choice of law rules, and to the extent that industries are affected, some business group is affected by these rules. They have a much greater stake and a much greater interest in just preempting the rules they don't like than in fixing the choice of law rules. So there's no organized group that's going to lobby for this, and Congress isn't going to do anything about it. So, I think there's not much chance for the federal courts either, as that seems to be the verdict of the last 80 years. But the appeal I would make to federal judges is, this is your turf. This is a discrimination issue, right? This is people being treated unequally because of where they come from, or whose law they're relying on. You should not view this as just an economic matter or a state law tort matter as a boring matter. You should view this as a central part of refereeing the system of justice among the American people. I don't have any hopes that they're going to respond to that, but that's the pitch I would make.
Yeah, I feel similarly about Congress. There was an article written in the 1990s, I think, boldly predicting that Congress was going to act soon to codify federal choice of law rules because it would be in the interest of big business to have a uniform set of rules. And instead, exactly what Professor Laycock said happened. It just turned out to be easier to get federal law and federal preemption on anything that you might get sued for rather than a choice of law rule. So I don't know that anybody self-interested can really be counted on here. I mean, one possibility, I try to look back somewhat at the lessons of the 19th century, the codification movement. You know, for a long time, it was considered a pretty radical idea to even have like a lot of statutes on a topic where Congress would come in and codify a bunch of common law rules, or people would collect all the common law rules in a book, and that would be enacted as positive law. Although people like Jeremy Bentham were strong believers in this and spent decades sort of writing about why it was a good idea, and then anytime any politician anywhere in the United States like indicated they might be interested, he would send them a copy of his book and bother them about it until, you know, eventually the kind of intellectual movement built up enough people who cared about good government that places started to do it. So it may be that the answer is, you know, 75 more panels like this one, with the hope that eventually somebody who cares about the system as a whole on a kind of issue where you don't score any political points will just try to make the world a slightly better place. I think it's right that in the meantime, federal judges could do more. You know, the Supreme Court could do a lot by overruling Claxon and announcing that there will be general law, conflict of laws principles, even if it's not willing to go as far as to overrule Erie. It could do a lot to make that better. Federal courts could do a lot to point out the ways in which that would be better, and at least to try, as Professor Laycock says, to sort of recover some of their original role as neutral arbiters between the states. Again, I'm not holding my breath, which is why the people who care about this issue are the people who are holding this panel. But sometimes it happens.
Professor Laycock, do you have any questions for your fellow panelists? And if you don't, we'll just move into the concluding statements and begin with you. But either is fine with me.
Yeah, I guess we've heard hints of this, but I'd like to ask Professor Sachs, why do you want to get rid of Erie? What's the problem that you see there?
So I think the fundamental problem with Erie is that it's just incorrect as a statement of American law. It's not the case that general law is, you know, excluded from our system. It's not the case that federal courts always have to defer to a state court's interpretation of some standard that is not of the state's authorship. So if there was some issue involving a rule of international law, let's say, it's not at all clear that a federal court has to defer to what the state court thinks about that just because it's in the district for that state. Indeed, I think the problem with Erie is exactly the same as the problem with Claxon, which is that you know, these are topics that are not within the control of any one state, although a state can borrow them if it wants to, or in many cases can supplant them. So if a state does decide to use the common law of contracts, it can, you know, federal courts and state courts both know what that is to the same degree. If the state wants to apply a different rule, either by adopting a local usage or by adopting a statute, it can do that too within its scope of authority. Part of the problem with the areas we've been talking about, things like state borders, personal jurisdiction, choice of law, is that it's not clear that the state has the final word on where its borders are. You can't just pass a statute and say, now we own New Jersey. You know, you have to actually comply with rules that are not of your own authorship, and that's where it actually has some teeth if the federal courts are applying general law in ways that might deliberately not look to state statutes or state local usages that might purport to abrogate them. But I also think that once you stop using Erie, a lot of other things start making a lot more sense. So I think one of the reasons why there's been so much pressure to read into very obscure constitutional phrases, very detailed codes of interstate relations, is because the thought is it's got to be in the Constitution or else it doesn't exist. It's got to be in some statute or else it doesn't exist. If you're more comfortable with the idea that there might be unwritten law that's out there that the federal courts are allowed to apply so long as no one else within their scope of authority has abrogated it, then it's easier to have those areas of law.
Okay, so at this point, I think we'll each take about a minute or two. I'll go last to just talk about anything that you thought we were going to talk about or wanted to talk about, but just didn't get a chance to cover. Any kind of closing thoughts, anything you want to leave the students and the viewers with in terms of a main theme. And we'll start off with Professor Laycock, and certainly it can be even briefer than that, but I want to turn it over to you for what you think is important.
Well, I'm comfortable with the idea that there's a general law out there that federal courts should apply to federal issues, and I think that choice of law and scope of the jurisdiction of courts are inherently federal issues because there is no other neutral arbiter. Dividing the authority between two states is an issue on which neither state is neutral, but the federal courts or Congress could be neutral. But Erie, as I understand it, is about issues that are left to state law, and the common law of contracts, are better or worse, is state law. Congress could preempt a lot of it under the Commerce Clause, I suppose, but it hasn't. What's a tort? What's a breach of contract? Those are state law issues in our system, and as long as they're state law issues, I would apply Erie. I think the three principles I outlined, that we're all equal as American citizens, and the states are all equal, and the choice of law rules ought to treat us as equal. I think those are pretty appealing, and I think some of the results in discriminatory choice of law rules are pretty appalling, but they don't occur in a systematic way. They don't leave a large group of unhappy people who can organize. So the system has been unwilling to do anything about it, and I think that's a problem.
All right, let's move on to Professor Bode. Any last minute thoughts for those listening online?
Yeah. I guess I'd just say this is a sort of interstate relations in general is an area where it's kind of an area of puzzlement and tragedy for the constitutional formalists. I think it's something where the Constitution, it'd be nice if the Constitution told us more explicitly than it does, and I wish it said everything that that Professor Laycock says it thinks it said. And frankly, even if it doesn't say that, I wish the Supreme Court thought it did, and that would sort of make the world a better place, even if it's not quite, in my view, what it says. But failing that, I really hope Congress hires Professor Laycock to write a choice of law code.
Thank you. And finally, to Professor Sachs.
Well, I just want to endorse that last point. I would be very happy for Congress to hire Professor Laycock to write the code. And frankly, I think that's the real take-home point, is just call your congressman. This is something that is much easier to deal with through the prolixity of a legal code than through the general principles laid out in the Constitution that don't really specify very much, that sort of leave a lot up to other bodies of law to solve the problem. And if the courts are not going to be in the general law business, at the very least, they can be in the statute applying business. And this really seems like the sort of thing that is not easily dealt with on a case-by-case basis, but rather by a group of people sitting down in a room and legislating in advance.
Thank you. I just want to conclude with just a few thoughts on the conversation that we've had, and then also the symposium in general. This has been a wonderful panel, and I want to thank all three panelists very much for participating. This is the first time I've ever moderated an online panel, and I'm sure some of you have done this before, but I certainly have not. And the Federalist Society and the panelists did a great job of making my job easy, which I very much appreciate. And I also want to thank the Michigan chapter of the Federalist Society. My son is actually a member of that chapter, and I know how hard that chapter has worked over the course of the last year trying to put together the student symposium. And although we could not get together and have this conversation or any of the other panels, I know the chapter president Kelly and Adam, the symposium chair, worked extraordinarily hard to put this together. And I'm very pleased, although, again, it presented its own technical challenges, that the Federalist Society was able to host this. So I just want to thank everyone who played a role in this, especially the panelists, but also the people who organized it. And thanks to everyone listening at home for spending a Saturday morning and a Saturday afternoon listening to this program. Thank you.
Thank you.